The Alternative Corner, where we will follow topics of interest other than boxing. At October Ed, we always want to engage with our listeners and accommodate what our viewers want to listen to. Feedback is essential. Feel free to tell us yours.
Hello, good morning, good afternoon, good evening, good night, wherever you are. It's Apps of October Red, and we are back with the Alternative Corner. It's been 2 months since I last did a video, and I think we're on episode 15 now. So they're there, but we had a little bit of a pause because boxing got busy, life got in the way, you know how it does. But we're going to kick off back with catch up, I guess. And I thought the case that I wanted to catch up with first, you know, we spoke about Noel Clark, we spoke about Mr. Ward, we spoke about Tim Westwood, we spoke about Prince Andrew. Well, he's not Prince Andrew anymore, is he? He's just Andrew Mountbatten Windsor. So a lot changes. But we're going to go back to Tim Westwood, and why we've gone back to Tim Westwood is because he's pleaded not guilty. And I thought it was actually 15 charges. However, it's not. I thought somebody said it was 16, but yeah, it's 15 charges. So we're gonna run with that and go through what not guilty means. You know what I'm like. There's some people out here that might not understand or want a better insight to how the law works, what the next steps are, and potentially why he's pleaded not guilty. And we're going to go into that as we go on. So thank you very much if you've got this far. We're just about to start. In the UK, basically, when what they call a defendant, you have a victim or witness, and then you have a defendant, the one that's been hauled up to account for what they've been charged with. Obviously, it doesn't mean that the case is over. You can't just say, yeah, I'm not guilty, and everyone goes, yeah, all right, then see you. Thanks for that. Thanks for turning up. It doesn't work like that. Basically, this is when the work starts. It could have gone two ways. It could have pleaded guilty, and what would happen is they'd have a break. They'd, agree to that. And then they'd say, yep, let's get a pre-sentencing report, etc. And then they'd decide on what type of sentence he was going to get. So it's more open and closed when you plead guilty. And in this country, I don't know if it's like that for others. So if I've got any non-UK listeners in your country, how does your judicial system work? Do you get a reduction in sentence? For some crimes, should you plead guilty in the first instance? But he didn't. He said, nope, not guilty. So we're going to run over it. Like I said, you can go back and listen to the previous episode because I broke it down a lot there. So we're just going to cover on what's happened. It's recent. I think it might have been magistrates he's gone to. Yep, it would have been magistrates to start off with. He enters a plea and then he's been released on bail. So they don't deem him dangerous enough to keep him behind bars. They don't deem that. That's why he's been released on bail. But I'm sure those bail conditions are strict, where he can't contact any of the witnesses, any of the victims directly or indirectly, like send a message through his next door neighbour's cat, whatever. All of those, if he breaches the conditions in which he's been given for bail, then they've got every single right to drag him back in front of the courts and then potentially remand him until the trial date, which potentially has been set for January. I haven't seen an exact date yet, but we'll go through it. So this is a summary, a catch-up. December 2025. He appeared before Southwark Crown Court, where he pleaded not guilty. Pleas to 15 charges, including rape, indecent assault, sexual assault. These charges were made in relation to alleged offences involving 7 women in total, spanning from a period of 1983 to 2016. I'm old, and I was 5 in 1983, and I'm old. So it's a very long time ago, up until 2016. So when you look at the not guilty plea, what does it actually trigger within the UK judicial system? And this is what we're going to talk about. Not what goes on everywhere else, but what goes on in the UK, and why would a defendant choose to plead not guilty in a case of this magnitude? Because it's massive. 15 alleged offences. Now, I always say alleged because just because you are charged with something, it doesn't mean you are guilty. It's up to the courts to decide on the evidence that is given from both sides, both defence and prosecution, whether the jury can make a decision that they believe on a majority, that he is guilty of these alleged offences. That's how it works. Magna Carta, we've gone through all of that. That's what it's there for. Everybody is entitled to a free trial, and that's why I will say alleged, because they are at this time. He's not being convicted, he's only being charged. So in UK law, in the not guilty plea does not require the defendant to prove innocence. Instead, it places the entire legal process on the prosecution. The prosecution service must prove that beyond reasonable doubt that the alleged offences occurred and that the defendant was responsible for them. From this point forward, every stage of the process is about testing the evidence and not assumptions, reputations, or public opinion. So what he's done, he said, prove it. Basically, prove it. Now, there's a lot involved in prove it. When you're a witness or a victim and you think, okay, oh my God, there's 14 other women that have alleged this, I'm not alone. Gosh, he's definitely going to plead guilty to that. I mean, what's he going to say? He's going to look terrible if we don't know each other and we're all saying the same thing, or we're all giving, different versions of offences that he committed against us. So those women, let's do the statements, let's do potential video interviews if they're vulnerable, let's show, maybe messages or photographs, or, 2016, 1983, you struggle for CCTV, but was anything on camera back in the 2000s, etc., etc. And they will think, as a victim, as a witness, you're going to think, damn, this is really good. The prosecution have been really supportive, the likelihood, when you get charged, it has to go to the prosecution solicitors and they have to look at all the evidence that's been given to them so far and say, yep, we're likely to secure a conviction, because if they're not, they'll drop it and they won't bother with the case. Because if they don't believe that the likely outcome is a conviction, they're not going to bother with it, because it's very expensive for them not to get the result that they want. It's costly. Unfortunately, if there's any victims listening to this, it always works out to the cost. The evidence has to be really overwhelming, and it would have been scrutinised quite heavily. So he's at the point where he's gone back to court and he says, basically, prove it. So those victims, those witnesses, those that have provided statements, etc., that have gone through what they believe to be harrowing experiences, are now going to have to relive that through court. They may apply for what they call special measures, where they don't, any victims of sexual offences are entitled to anonymity unless they agree to waive it. And we've talked about this before. We've gone through this with obviously the Noel Clarke, but that was civil. It wasn't in obviously criminal. It was in civil court. Okay. But in the real world, in criminal court, sexual offences, you are protected by anonymity unless you say, no, forget this. I want him to see my face. I want him to see what he's done to me, etc., etc. There's all that. But they are protected by anonymity. But make no mistake, it's still daunting and upsetting for anybody to go to court and have to relive that experience. And not just that, be cross-examined by highly trained defense solicitors that want to get into the jury's head to prove that you're lying, that you're making this up, that you've done this before, that there was consent. So from a victim's point of view, hearing him not plead guilty, this is basically what's coming next. You're going to court, and that can be quite off-putting, and sometimes people can pull back, and it takes potentially a lot of persuasion to say, no, we're going to run this, he's going to get convicted, we believe your story, etc, etc, we've got the evidence, we can prove this, etc, etc. So there we are. So it pushes all of the ownership from the defense back onto the prosecution and the victims. But what it also does, and the thing is, it can give evidence, or he might decide not to, but the pressure, one for a better word, don't get me wrong, because his name's tarnished, you've got people like myself, YouTubers, talking about it, so there's no real escape from what is now attached to him, whether he's guilty or not. And like I said, everyone is entitled to a fair trial, okay? So I'm not saying he did it, I'm not saying that he didn't. I've got my own personal opinions, but for this, we're keeping a balanced point of view, yeah? So he doesn't have to necessarily give evidence. What's going to happen is the scrutinisation of potential victims and witnesses. So what happens next then? He's already been charged, but obviously the investigation doesn't stop. They're probably going to have to go back to witnesses, go through all of the evidence once again, have a look at the statements, yeah. There's potential video statements, and there's another part of the case where there's unused material. It's evidence, but it's not being relied upon as yet. We're going to use this to get the charge. So there's some of that unused information that may come out. In other words, potential other witness statements that have spoke to potentially the victims, that will then potentially come out of that unused box and then go into actual used evidence, something that will be brought to court. They're going to spend a while going through all of the evidence. And if you're looking at the timescale from 1983 to 2016, there's going to be a hell of a lot of evidence to review. And like I said, the later you get towards these times, you're going to have potential mobile phone evidence going through mobile phones that have been taken off people to secure evidence for potentially years that they're not going to get back, because though all of that evidence will need to be reviewed, because now the defense are going to try and pick holes in absolutely everything the prosecution have put towards them. So they've got to serve that evidence. Is there any potential new witnesses? I know when there's cases like this of a potential serial nature, they'll state to people, they'll do even like a public appeal, if you know, if anything like this has happened to you, please come forward, etc, etc. Because as we know, if there's a lot of people saying the same thing about one person, it implies, and this is just the way the brain works, it implies that that person is guilty of doing something. It's just the way it works. So the more evidence, but the more evidence that has quality, the better. So that means they can now open the channels out to say, okay, it was 2016, or say, for example, when the prosecution made their decision, they said, right, we've definitely got solid evidence between 1983 and 2016. I know you've got recent statements, but we're going to keep those back for now, because the more, you know, solid evidence that we've got is between those two date barriers. Now, the prosecution will be looking at that and saying, okay, we've got some recent statements, more post 2016. Now we're going to have to really look into these. Now we're going to have to potentially gain some more evidence. It's going to be tricky if that trial is set for 2026 January. The courts will decide whether they're going to allow anything further, anything to bolster what they've got. but at the moment we've still got that rigid date range. Disclosure, and this is what I was talking about, they're going to have to present all of that evidence to the defence. So all of the evidence that they've got, they're going to present it to the defence. Defence are going to go through it, and they're going to find gaps. But they're not going to tell you about those gaps. They'll leave those gaps till the trial itself, and this trial will probably go on for about 3 or 4 weeks, high profile, etc, etc. And I really might try and go down and listen to this if I can, so I can give you guys fresh info off the ground, but we'll see. So trial could potentially take a long time due to the volume and the sensitivity and everything that surrounds a case like this, but all information that the investigation side have got will need to be presented to the defence, because they need their time to look through it. They could be, okay, that's fine, or they could come back and say, well, this statement from X, we need further information on that, or whatever, and then it's up to, obviously, the investigation side, if they've got that they can provide it or not. There's probably going to be a little bit of to-in and fro-in between prosecution and defence. Digital records, historical documents, travel logs, correspondence, prior statements are scrutinised again, especially in non-recent cases. Like I said, this is a historic case. This is not something that has been in the last couple of years. The process can actually take a really long time, and that's why I'm struggling to think, why is the trial already set for January? But we'll see. So let's go into potentially why Mr. Westwood has pleaded not guilty. Evidential challenges. Many of the alleged offences go back decades. Like I said, I was 5. I'm old now, but I was 5 in 1983. Physical evidence may no longer exist. Say, for example, were those things reported at the time? Were those ladies that alleged rape, were they physically examined? Were there swabs? Was there DNA? All these sorts of intricate detail, is that still available, or did they report it as a historic? Did they go into the police station in 2016 and say, I was raped in 1983? That happens. So how are we going to get the evidence for that? So does this evidence, does it exist? Have we got that? Witness memories may be contested, and this is, like I said, where the defence will look to pick the witnesses apart, literally look to create that doubt in the jury's mind. You know what it's like. You're sitting there, and say, for example, something's happened a while ago, you can't really remember because it's happened such a long time ago, and people are going into intricate details, and you're like, I can't remember, I don't know. The jury could think, well, are they lying? Or would they think, well, actually, it was that much of a long time ago. We've got all of the substance that we need from them. Let's make a decision on that. But once that doubt starts to creep in, that's when the prosecution's case could fold. Locations, records, or corroborations may be unclear. A defence team may believe the prosecution cannot meet the high criminal threshold required for conviction. So it's literally a roll of the dice, and it is, and it's a massive risk. But the defence obviously believe that they're in a strong enough position to take that risk and are willing to take it. We go on to the credibility once again at the trial. The defence has the right to challenge inconsistencies in accounts, question delays in reporting. Like I said, did you report it at the time, or did you leave it for years? Examine prior statements and external influences as well. Remember, this has been all over the media. One of the things about high profile cases is it's extremely hard to choose the jury. 12 people that have got no idea or have had minimal influence around the case, because that also can be very, very toxic. And I think that's why some people are trying to bring in people not being allowed to report on cases that are at charge stale and only be able to report on them at the stage of conviction. Because you've got me telling you this, you've got other YouTube outlets, Main News, The Telegraph, or The Sun, other credible sources going into detail on what potentially could happen with this case. You could be sat at home listening to this and then you get the call, oh, can you be on the jury? It happens. So it's a difficult one when it comes to high profile cases. Obviously, it's not about attacking the complainants personally, it's about testing reliability under the law. But if you're standing there as a witness and somebody's going at you and you're in a panic mode because you're sort of on stage standing in front of everyone, all of those little details can make you not look credible. It doesn't mean that you're lying. It's not about that. It's about proving that credibility. It's about that evidence shining through at court. It sounds a bit crazy, but that's just the way it works. Right to a jury trial, and this is it. Everybody has the right to a fair trial. This is where the jury comes in. By pleading not guilty, the case will always proceed to a jury trial. 12 members, like we said, of the public must be unanimously or by majority satisfied beyond reasonable doubt. For a defendant, this is a fundamental safeguard of the UK judicial system. Denial of allegations. Westwood has consistently denied all allegations. Not guilty plea formally places that denial on the court and requires a prosecution to prove each charge independently. He might have been charged with 15. He might get convicted of all of them. He might get convicted of 2 of them, or he might not get convicted at all. They've got to prove it. This is where the onus now pushes back to the prosecution, and that's why most people will opt for trial unless the evidence is so damning. And we're going to do a deep dive on the Getz case as well, because obviously he's gone in and pleaded guilty. But let's get back to Tim Westwood, because that's what this one is about. What will the defence focus on? From now until trial, the defence will likely focus on disclosure, failure, or gaps. Yep, they'll give you a certain amount of time. You've got to submit this evidence, otherwise it won't be admissible. Inconsistencies across the decades. Like I said, the time is always difficult to prove such serious offences, especially when there's a lack of DNA or any other physical evidence. Photographs taken at the time, bruising, phone records, anything that could have been there, but it was a late reporting, so all of that evidence is gone. Procedural fairness, to make sure that, and procedural fairness is a very, very difficult one when you're in the public eye. I think it's very, very difficult to have that fairness when somebody is in the public eye, but they'll try and do that. So if it was, somebody that was not in the public eye, non-celebrity, they may be able to have that procedural fairness in a better way, because the likelihood of the jury knowing who was on trial is going to be 0, because those are one of the questions that you ask. Do you know this person? But a lot of people are going to know who Tim Westwood is. His notoriety. He's been a DJ for those several decades, all the way through my teenage years. I remember him as being a hip-hop DJ that broke through to the US. Whether the CPS threshold was properly met, so they're going to test whether the Crown prosecution actually charged him, rightly. Was he actually charged rightly? Did you really have enough evidence to go for a charge? And this is why, if the CPS, the Crown Prosecution Service, decide that there's the chance that this probably won't succeed, they won't touch it. So they should be okay with the threshold being met. Unless there's any corruption, but whatever. This is standard in any criminal litigation, especially where cases are complex and non-recent. But also, to add on to that, it's complex, it's non-recent, and it's a forward-facing public figure. It's somebody that a lot of people will know. So this case is very, very complex because of that. So the courts, what will they do? The process will include pre-trial review hearings, and this is why I'm saying they might say, look, we've got to get more evidence, we need to do this. Or the defence might say the prosecution just landed us with this, so we've now got to look at that. So potentially the trial date could be pushed back. I'd be really surprised if it goes ahead in January, but hey ho, who knows? Legal arguments on admissibility of evidence such as potential hearsay evidence, where it's somebody that heard about it but is not necessarily a witness or a victim. So they'll say, well, or say, for example, somebody tweeted out, somebody in the celebrity world, I always knew he was a wrong 'un. And so then somebody's trying to say, but look, there's a general consensus about people thinking that he's like that. Is that actually admissible in court? Is it evidence, or is it just people going online saying stuff based from their gut feelings? Gut feelings, whether they're right or wrong, it isn't evidence. And if it's not evidence, it doesn't have a place in the UK criminal court system. Jury directions being prepared as well, timelining for witnesses, just laying it all out, chronological order. Everyone knows what they've got to do. Witnesses, are you comfortable with going to court? This is something that witnesses and victims, are you comfortable with going to court? I know you said you was okay about it at the time. Is there anything that we can do, etc., etc.? And really going through that timeline of events. It started in 1983, so we start with the very first month that it started in 1983, being able to provide that chronological order. Say, for example, 1983, 3 girls came forward from... We'll say 10 girls came forward from different shows that he performed at, and say maybe 2 or 3 girls were at one show, but they don't know each other. They came forward at separate times. How would they know? Or everything's in a chronological order, because if there's a correct timeline, you can prove consistencies, but as a defense will see, they can also prove inconsistencies. Yeah, and even if it's an error with the date and the time and the location, these are the things that the defense will pick up on and go, hold on a minute. How could he have been there when he was in Cuba on holiday? Whatever. All of these things, it goes down into the minute detail, because what you've got to prove, like I said, once again, is the credibility of these witnesses. So we look at the provisional trial date's been set for January, reflecting the complexity and the seriousness of the case. But to me, I don't know how they're going to do it that soon, but we'll see. These proceedings are active, and this is the caveat that I have to do. Yes, we are talking about it, and that's why I said it's a balanced point of view. It's not about my opinion in this. It's about what is being reported on, and I'm telling you about the procedure of it. You must always presume somebody is innocent until they're proven guilty. Presumed innocent until proven guilty. Those are the rules. And you have to remember that all of the witnesses have a lifelong anonymity behind them, unless they choose to waiver it. And the outcome will be determined in court and not online. So I do think they're going to be really hard done by to get a jury that's sterile. Because I think even more recently, I think if you guys have watched the Diddy documentary on Netflix, some of the jury, I think one of the jury or a couple of the jury spoke out, and it was like, oh, this is not good at all. They're going to have to be really stringent with the jury, but you can do all those checks online. You can have a look and see what they've posted, what they follow, what they look at, etc., etc., etc. So they're going to have to do all of that. A lot of careful consideration and selection is going to have to go into choosing the jury. So public discussion, it needs to remain factual. So this is what I'm telling you, this is what it is, the procedure, etc., and responsible. So yeah, so that is it really, in kind of like a little summary box for you. Obviously we'll be keeping an eye on it. It's something that we are interested in, and if you're interested in this side of my YouTube vids, you know what to do. Like, subscribe, we'll do all that amazing stuff. And yeah, I think we're going to leave it there, as we say at October Red. Stay ready, and more alternative corner stuff coming soon.
Thank you for listening to The Alternative Corner. Most of our listeners have not yet subscribed. We kindly ask you for your support by subscribing to our channel and to share our content. October Red is sponsored by SAUK, Maximum Security, Minimum Fuss.